Court of Appeal in the 4th, 5th District of the state of Florida is now in session. The Honorable Brian D. Lambert, Chief Judge presiding. All persons having business before this court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Thank you. Good morning. Welcome to our first session of the newly realigned 5th District Court of Appeal. And Happy New Year to all. As our marshal indicated, I'm Judge Lambert. I'm the Chief Judge right now for another 170 days. And I will be presiding today over we have 3 cases for oral argument. Let me introduce the panel. To my right, your left, is Judge Carrie Evander. For those of you who may not know, Judge Evander is retiring as of February 28. This is my last chance to sit in person with him in OA, so I appreciate the opportunity to have sat with him all these years, and I'm going to miss him, and the court's going to miss him. But his wife said it was time for him to retire, so as all of us who are married understand, that's the route we're going on that one. So the governor's accepted it, and they started the process. So Judge Evander will be here one more week. Next week is his last week of oral arguments. And to my left and your right, we are pleased to present to you Judge Harvey J. Judge J is one of our newest members of the court. He came to us from the 5th District Court of Appeal. Or first, or somewhere, I don't know. Or he showed up off of Beach Street and we gave him a robe. So he came from the 1st District Court of Appeal. He was a trial lawyer before that, sat as a circuit judge up in Duval, and was in the 1st District Court of Appeal for roughly 6 years before he joined us. We're very happy to have Judge Jay with us and the rest of our newly appointed members and Judge Maker. So as we go forward with our new court, just for those of you who don't know, I'm not sure why you wouldn't know, but as of January 1, the 4th Circuit, Duval, Clay, and Nassau County is now within our jurisdiction, and the 9th Judicial Circuit, Orange and Osceola County, has now been transferred over to the newly created 6th DCA, where Judge Sasso is the chief judge over there. So we wish them well. But all right, that's it we welcome Judge Jay. So we're happy to have him here today. It's his first OA with us. So the 3 cases this morning. And just for the record, it's Tuesday, January 10, 2013. All civil cases. Each side will have 20 minutes to argue. The appellant will have 5 minutes on rebuttal unless you, the appellant, tell me you want a different amount of time, and I will set that. On the clock, you will see there should be a yellow light will come off for the appellant once you're into your rebuttal time. If you want to continue using your rebuttal time, that's up to you. I will give you the heads up that you're in the rebuttal time, and you choose to exercise your time accordingly. If you have any type of electronic devices, I'd ask that you either turn those off or put them in the mute position so it doesn't interfere with either your argument or your opposing counsel's argument or with the court's questioning of you. So that being said, welcome. Happy New Year. First case, 21-2295, Randy Rhodes versus Lilamissette Rodriguez. I apologize if I mispronounce anybody's name.
About the coffee.
Oh, that's right. We have 3 cases today. So what we are going to do after the second case, we're going to take a break and go into the lounge that we have, the lawyer's lounge, and have coffee. If you want to meet with us or talk with us about anything other than your case, we'd be happy to visit with you. You get a chance to say goodbye to Judge Evander and say hello to Judge Jay, and I guess ignore me completely if you want. Probably your best choice, but all right. So you're not obligated to go, just if you want to. All right, counsel. I think I've extended this as long as I can.
Well, good morning, Your Honors, and may it please the Court. My name is Derek Angel, and I represent Randy Rhodes in this appeal in a case that should have been a routine low-impact rear
Let me add 5 minutes rebuttal. You all right with that?
Yes, sir. Thank you.
Okay, very well. Thank you.
And the 2 orders on appeal of most significance, the order imposing sanctions and the separate order granting adder, both constitute abuses of discretion, which independently we believe require reversal, and therefore we request the court to remand this case, to vacate the sanctions with instructions to reinstate the jury verdict. I was prepared to begin with the editor issue, which is actually, I think, the most important to the litigants. But last week, this court notified the parties that we should be prepared to discuss the recent Supreme Court decision of Florida Bar versus Arugu. So I think it's more appropriate that I begin with the discovery issues in this case.
And let me mention, we recognize on the sanctions order, there's two issues. One is whether there is misconduct by counsel, and two is, even if there was, what's the appropriate sanction? I don't think that case, the Florida Bar case, goes to whether it's the appropriate sanctions or not, but you took the position you briefed that there was no misconduct, so I think it is relevant to that issue, and wanted to hear from you since neither party had cited it, and there's no supplemental authority. So,
sure. And so I don't think the facts of Arugu bear on our case. I think that it discusses some rules which do, rules of professional conduct. Mr. Arugu, in that case, it was a family law matter, and he represented the husband, and apparently the wife's father had claimed an interest in marital property, and so he sent NPNPs to the bank, which held a mortgage. And I guess the process is the same in family court as it is in civil court. And you send NPNPs, you serve them with the attached proposed subpoenas. Of course, I know your honors are all familiar with the process. And then if 10 days go by for the opposing parties to object if they want to. If they don't, then you are permitted to serve the subpoenas in the identical format that they're proposed. Mr. Arugu, after the 10-day period, added additional types of documents, including credit checks, personal information of the father-in-law, and then he filed the subpoenas, which may be something different in family court. We just mail ours. But the other lawyer caught the difference, contacted Mr. Arugu, said, hey, what are you doing? In so many words, and Mr. Arugu said, I'm going to send these anyway. So I don't think anything like that happened here in either direction.
well, here you had an objection. You had a subpoena go out, and probably was no prejudice here, but the Supreme Court did not mention any prejudice in that Florida Bar case. And they seem to emphasize in the Florida Bar case that for 2 weeks or whatever, he took no action to recall the subpoena, even though there was an outstanding objection. And also that the effect of that conduct was to make a misrepresentation to the non-parties by telling them they had an obligation to respond to the subpoena. So on those last 2 points, the failure to do anything after there had been an objection, and the argument that a misrepresentation had in essence been made to the third parties, is there any difference in this case on those 2 points?
Well, yes. In this case, it was Ms. Pruitt, paralegal, actually used to work with me at O'Connor, believe it or not, but she immediately caught the problem when the objections were filed hours after she mailed the subpoenas. She contacted Ms. Gourlay, the paralegal with Bird's office, and they talked about it. Ms. Gourlay said, I understand, I will speak with Mr. Bird and let you know what we're going to do. That's in Ms. Pruitt's affidavit, which is uncontroverted. No one followed up or responded from Mr. Bird's office. So still within the period of time that the subpoena was due, Ms. Pruitt on her own, and sure it was 2 weeks, but it wasn't the last day of the subpoena period, she again followed up, CC'd Mr. Bird, who then claimed he never saw that email, and she also notified the non-parties.
So I'm a little puzzled by the effort to put the blame on the opposing counsel. The mistake was in defense counsel's office. You got an objection. I don't know if you were searching for a second objection, but you got an objection. And as the trial judge brought up, why wouldn't you just notify the parties and say, hey, there's been an objection, let the attorneys talk before you produce any records? I mean, that seems, if the lawyer makes, we all make mistakes. It just surprised me that the lawyer makes the mistake and then instead of correcting it, doubles down and blames the other side. And I'm having trouble with that part of the response.
Well, I do think they did take, first of all, there's no indication that Mr. Goebel was personally involved with this. I understand that the paralegal is an agent, for sure.
Right, but the 16 days that passed before there's notification, don't respond, there's an objection to the subpoena, wouldn't Mr. Goebel be responsible for that?
To the extent he knew about it, sure. But nonetheless, he did, or Ms. Pruitt, again, immediately the day of, she contacts the plaintiff's lawyer, and then 2 weeks later, again, on her own, incumbent on herself, notifies all.
She already had an objection.
Yeah, and then.
So do you want a second objection?
Again, she did notify the non-parties of the objection 2 weeks later, which is well within the 30 days for them to respond.
But you already had gotten documents from 4 of the 10 medical providers.
As it turns out, some of those documents had been
And
provided.
they had been under the understanding that they had a legal obligation to respond to the subpoena when in fact they did not. Would that be a fair statement?
That is correct.
Okay, all right, thank you.
And the documents were forwarded to the plaintiff's lawyer without any comment from them and said we get this motion. So if that was the reference to that case, the Arugu case, I was also interested in the Arugu discussion of Rule 4-3.4, that a litigant, a lawyer is not permitted to interfere with the legitimate discovery of other lawyers. And in this case, these 2 objections, they are legally meritless. And I don't think there's any argument on appeal that that's not the case. And these, you got to understand, when these objections were filed, which were not directed to the back center, by the way, if we're going to be very technical.
You say they're meritless, but the rule clearly allows the opposing party to object.
Absolutely.
I mean, categorically, correct?
Sure. Yeah.
And it doesn't say in the rule that I remember, we can read through it together, the type of objection that needs to be advanced is simply enough to object. You'd agree with that, would you not?
The way it's written, yes, but I don't think we can just take that in a vacuum. I think it's
And
implicit.
there's a mechanism too, counsel, for a records pickup, which you recognize in your brief, correct?
And was done repeatedly in this case. I counted 131 notices of deposition in this case.
But I guess the point, I don't want to speak for Judge Evander, but certainly my point is, maybe there should be specificity in the rule, but as it stands now, there's not. It's simply enough to object. And once that happens, you have to avail yourself of another process.
And
True?
I never disagreed with that in the brief. In fact, I conceded that point, Judge Jay. And I do think, though, that it is implicit that in a rule that says you may have an objection, that the objection should have a legal basis.
But you don't get to decide whether you think the objection's good enough or not. I mean, that's the point I think everybody's making here.
Correct. And again, I'm not disputing that. But the options that the receiving party to the objection has is twofold, right? They can either call up the objection or set a records pickup. But let's think about that. When a lawyer interposes a frivolous objection, which again, there's no argument, there's no legal basis here, then calling up an objection is not something that you can just snap your fingers and have done. As trial judges, you all know, many judges today will not hear a contested issue ex parte. It can take 6 months to coordinate a hearing on these things. Or doing a records pickup, which costs the court reporter and what have you. And the first objection in February of 2018 in this case, the NPNP, which again did not include the back center, was directed to 5 different providers. So by interposing this objection, you're either forcing to set a hearing 6 months down the line, or you're requiring to hire 5 different court reporters.
One thing in your brief, you kind of suggested that, when you have a plaintiff in a personal injury case and there's medical records, there's clear entitlement, but that's not always the case. Would you agree? I mean, there can be a medical condition that the patient references to the doctor, which is not at issue in the case, or there could be information that's otherwise objectionable that's in the medical record which doesn't deal with the medical treatment.
Sure, there can be all sorts of reasons why you can have
Which is why the rule is there.
And I agree with that, but in this case, there's no indication of any of that. In fact, the objections themselves spell out their purpose, which is in some...
I agree there's no prejudice, but I'm just having trouble distinguishing the fact of there being no recall, if you would, of the subpoena for 16 days and getting documents and letting that misrepresentation to the non-parties linger out there. So, but...
A couple of issues on that, Your Honor. First of all, this is only as to the second objection, which is in January of 2020, not the 2018, which nothing ever became of those. Those subpoenas were never issued. Everything was done through the records pickup, which got conflated, I think, in a major way at the hearing. Also, as we reference the lack of prejudice, we have to keep in mind this case is a causal case, which Arugu, of course, was not. That was a disciplinary case. And the amount of prejudice is absolutely, to the litigants themselves, is absolutely relevant.
Yeah, why don't you talk about the propriety of the sanction chosen by the judge?
Well, the causal factors are not just perfunctory. I don't think it's appropriate for a trial judge to just list them and put some general language to give us meaningful review at the appellate level. The specific facts that the court found that supported the sanction were a couple statements and openings at the first trial, which on appeal, my friend Ms. Peak agrees were truthful. They were just used to paint a picture of bias on the part of Dr. Mahan, which I think is completely appropriate, to say the least. And that this issue, not even with the 10-day thing, or the 16-day thing, understand that was not in the motion for sanctions. That was something that Mr. Goebel, I think, interjected himself because he thought that's what the motion was about. Really, it was about this theory that the defense uses old subpoenas for continuing discovery tools, which there's no evidence of that happening. So,
Well, the letters did reference old subpoenas.
and frankly, again, this is what I think this record could have been developed better by the plaintiff to obtain this level of sanction, where what was happening there was Ms. Pruitt was following up on the records pickup depositions, not on subpoenas. I know she used the term subpoena, and that term was conflated again in this hearing, but she was following up with a non-party deposition, not a subpoena.
Would you agree, whether it's the paralegal's mistake or the attorney's, that it's improper to send a letter saying, based on prior subpoenas, we want, in essence, updated records? Would you agree that's improper?
In a general statement, Your Honor is correct, but that's not what happened here. She was following
I
up with...
understand you have the depositions in between.
Yes, and so what happened was the deposition was noticed, the records pickup, and that was not fully complied with. So Ms. Pruitt was following up with the deposition notice on what was already owed to the defense.
But from the doctor's perspective, they got a letter saying, based on our prior subpoena, we need these other documents.
Because
I
they
mean,
didn't...
the doctor wouldn't know that it's based on prior deposition.
Understood, but again, they were documents that the doctor had already been obligated to produce. These were not new documents. So that's I think, a critical difference.
Well, assuming Mr. Goebel's offenses are sanctionable here, why do you think that the trial court's sanction of striking the pleadings is an abuse of discretion?
And I was getting there, and I appreciate that.
Trying to help you get there with 7:40 to go.
Yeah, this is about as quickly I've seen a clock tick in a while. So again, there's many sorts of remedies that could be levied in response to which I think that this is, again, the sanctions that were cited had nothing to do with the 16-day window thing. That was not in the motion. That was not the issue. It was something that didn't even happen. But assuming, as Your Honor asked me to, that there was a sanctionable offense, striking of pleadings is a death sentence for a defendant. I mean, you're basically deciding the case against the defendant. And not only that, in this case, precluding the defendant from cross-examining the expert witnesses in any meaningful way and producing any evidence whatsoever. It's amazing that the jury did what they did, but in thinking of other things that could be accomplished, there's myriad sorts of remedies that could have been considered, and nothing indicates that the judge thought of anything less.
Like what? You know, we're all former trial judges, and one of the things we would always scratch our heads is when the appellate court would reverse and say, well, that sanction's too severe, think of something else. And our response at trial court land was, well, what do you think we should do? So what do you think he should have done here? How about that?
Well, I mean, that's really not our job here at the appellate level.
Well, I'm asking you, and that's part of my job.
Sure, I understand that, but I mean, we look at COSEL itself. It talks about things like a fine. I don't know that would be appropriate or something to that nature. But when you have, particularly as Judge Evander was pointing out, zero prejudice to the litigants, and let's not forget that's who the focus is supposed to be here, not the lawyers. This is destroying Mr. Rhodes' case, who was. I think everybody but the 6 people in that jury would have anticipated would have a judgment that would put him in bankruptcy. You know, that's where the focus needs to be here. And if again, if the court, despite my misgivings, finds sanctionable conduct, that's for the bar.
Let me ask you this. You know, usually when we talk about a trial court making credibility determinations, it's the witnesses. Now, here the judge found that Mr. Goebel had lied to the judge, had lied about, not remembering his time with Dr. Mahan, not remembering that he had hired Dr. Mahan before, not remembering the educational session, if you would. Are we bound by that credibility determination?
I don't think so, and I think part of the problem here, again, is that this inadequate evidentiary record. The plaintiff's version of what happened with Dr. Mahan and Goebel was completely based on hearsay and unsworn representations by Mr. Byrd. And for something like this, of this gravity.
I mean, for instance, the part where strikes me that Mr. Goebel said, I can recall 24 instances where Dr. Mahan was hired by Mr. Byrd, but then he can't remember the 7 times that he did per the interrogatories. Could the judge have legitimately found that was not a credible statement?
I don't think so, given we're talking about 2 days of colloquy, hundreds of pages where, one sentence here and there you got to look at the whole picture here. And I think it's pretty clear to me what happened was he retained Dr. Mahan in a couple of cases, that only one got to the point of deposition, which, let's not forget, Dr. Mahan himself forgot that deposition. These people are in depositions all the time. And when it was brought back to him, now it doesn't mean that Mr. Goebel forgot about the general circumstances surrounding Dr. Mahan.
You're in your rebuttal.
I recognize
Go
that.
ahead.
Your Honor. Thank you. I had planned to reserve 3, so 5 was generous.
There you go.
In any event, I don't think that on this record, without, and again, the gravity of this sort of an order and a ruling, and we look at Adams versus Barkman, right? There's an evidentiary hearing that predates the second trial. I think if you're going to grant a sanction like this, there has to be a full noticed opportunity to discuss everything. And I think that was an error, and I think the judge was sort of flying by the seat of his pants and making that ruling, which I do not think is appropriate, again, given the gravity, right? And I don't think the record was adequately developed to make a finding that this court is bound to answer your Honor's question, I think more directly from a procedural appellate standpoint. So finally, and I think we've covered as much as I can given the time, I do want to reiterate 2 points quickly, is that the additor is, again, a completely separate issue, has nothing to do with the touchy issues of sanctions in this case. And this is, I think, a paradigmatic example of a 7th juror finding and going over the jury who had plenty of bases to.
Does the amount of the auditor add, whether he said 500,000, 200,000, 1 million, or is really our focus just whether there's an abuse of discretion to find that the jury verdict was contrary to the manifest weight of the evidence?
I think that if it's $10 or $10 million, the cases tell us we're not to analyze the propriety of the additor itself, it's just whether there is an additor. And in this case, as long as it's not a judicially shocking result, and there was plenty of evidence from which a reasonable jury could find the way they did, particularly given the instructions that they had to, ignore the evidence of your eyes and ears, but find that there's a permanent injury. I think they did the best they could and a very reasonable result under the circumstances. And that part of this case, I think, is critical that is reversed. And finally, before I sit down, I do want to reiterate my point in the brief that I do think that the motions for sanctions were really reprehensible. I would implore the court, as I have done, to read those and pretend that it's your name and not Mr. Goebel's, and imagine being a lawyer, and how do you respond to that? And I do think that a rule that says when the motion to strike such a motion is made, and it was here, Mr. Goebel made the motion, stated the basis, and obtained a ruling, I do think that it's an error. I think it's a matter of law to grant such a motion. So thank you all for your time in this difficult case, and I will reserve my time for rebuttal. Thank you.
Okay, you're 125 in rebuttal. Good morning.
Good morning, Your Honors. May it please the Court, my name is Megan P. Kluka, and I'm here on behalf of Ms. Rodriguez. And, Your Honors, I think I will start with the lies. Mr. Goebel, Mr. Byrd, in his motion, he certainly did. He accused Mr. Goebel of lying. And Mr. Goebel, in return, accused Dr. Mahan of lying, and he accused Mr. Byrd of lying. But the trial court found that Mr. Goebel was the one who lied. And Judge Evander, you asked, do we normally overturn credibility findings? And the answer to that is no, because appellate courts, we're reading a cold record. We don't get to assess demeanor. We don't get to look at body language. We leave credibility to juries and judges who are in the room. But in this case, on the cold record, you can see the lies. And the discovery conduct, Your Honors, I would represent...
Let me stop you there, counsel. There is no evidence in this record that Mr. Rose lied, correct?
Correct.
And Mr. Goebel's pleadings are not being stricken in this case. You'd agree with that as well.
Correct.
It's Mr. Rhodes. So is there not a disconnect between the sanction and the purported bad behavior in this case?
No, Your Honor, and here's why. I would
And maybe work into that, the constitutional implications too, but go ahead.
So I would point you to the cases we cited in our brief of Adams and of Jones v. Publix. And Jones v. Publix, again, the actual granular details of what happened in that case, the defense counsel knew of the address of a witness and basically withheld it. They said, oh gosh, we didn't know about it. And finally, based on the dogged persistence of the plaintiff's lawyer was able to persuade the judge, wait a minute, it's there in one of their reports, they just didn't give it to me. And the trial judge said, oh my gosh, you're right. And
So
this
let
court...
me ask you this, counsel. Should we make it the pattern of this court to uphold the striking of pleadings of innocent parties because of bad behavior of lawyers? Should that be the jurisprudence of this court?
Your Honor, in circumstances like this one, and I'll take you to Jones. In Jones, this court said that it was only through the counsel for the Joneses persistent that defense counsel's deception was revealed. And this court said, for whatever reason never expressed in the record, in the face of multiple opportunities and considerable provocation, the trial court decided not to strike Publix's pleadings for their counsel's misconduct. If the trial court had done so, the sanction would have had our support. And in Adams, same...
Is there not a difference, though, between a corporate, a savvy, day-to-day litigation party and a man that had never been through this process before? Isn't that a distinction between the case you just recited for us?
Your Honor, as a plaintiff's lawyer, I don't think that that's a fair characterization.
So it's your position that plaintiffs who have committed no misconduct, and I assume that would be your position on your client in this case, and if Mr. Byrd had done something at trial to cause a mistrial, it should never be considered, or it should be considered, that Ms. Rodriguez's pleading should be stricken. I'm just trying to understand.
Oh, no, Your Honor, I don't mean to draw a distinction between how the sanction or how the penalty should be applied to a plaintiff's lawyer or defense lawyer. It should absolutely be even. And if Mr. Byrd had lied to the trial court to obtain a benefit on behalf of his client, then absolutely, Mr. Byrd needs to call his malpractice carrier.
Suppose we were to find that Mr. Byrd was the cause of this mistrial. Would it be valid for Mr. Goebel to file a motion to strike your client's pleadings based on the cause of the mistrial in this case?
Your Honor, for causing a mistrial, I don't think so. The problem was that the reason that the mistrial was caused was because of Mr. Goebel's deception. And, Your Honors, I would also...
I want to ask you about that because I'm not sure I agree with you. Mr. Byrd, there were 2 court orders from Judge Harris that were not followed by Mr. Byrd. You would agree with that, would you not?
No,
as
Your
far
Honor.
as the disclosure of Dr. Mahan? I mean, the experts had been, the expert disclosure time had ended in this case, correct?
So the expert disclosure time had ended. Dr. Mahan was disclosed. There was a ruling that said Dr. Mahan can offer his opinions, but he can't testify about this one MRI because he didn't look at it when he was examining her as her treating doctor. And then that was, I think, 2016. The case didn't proceed to trial until 2018. At that point, Judge Coons is presiding, and Judge Coons says, it's been 2 years. If you wanted to take an update deposition, if you wanted to do something different to obtain this information, you should have done so. I'm going to allow this to proceed. There's no violation by Mr. Byrd. Just Mr. Goebel objected. Judge Coons ruled. Mr. Byrd didn't do anything wrong.
Well, let me ask you about this. Was there a request for Dr. Mahan's deposition?
That was Judge Coons' point, that Mr. Goebel
Was
didn't...
there, after it was allowed, was there a request for Dr. Mahan's deposition?
Your Honor, I couldn't tell you with absolute certainty, but
They say in the brief there was, and that Mr. Goebel said, I'll take his deposition at night during a break. Is that something that Mr. Byrd should have allowed in this case? I'm just
Your Honor,
asking.
it's not up to Mr. Byrd to allow it. It was up to Judge Coons.
Wait a second. Discovery is by the parties, counsel. I mean, you're telling me that if Mr. Byrd had gone to Judge Coons and said, Judge, I have no problem to sanitize this record with Mr. Goebel being allowed to depose Dr. Mahan. You're telling me the judge would not have allowed that?
Your Honor, I'm saying that that Mr. Goebel said, I want this case continued after it had already started. He said, I want the case continued because I am not ready for this Dr. Mahan stuff. And Judge Coons said, no, your opportunity to do that was before this trial. This is going to proceed.
As I understand the record, there was a request for a deposition, and you don't recollect that, I take it.
No, Your Honor, I don't recollect that specifically, and I don't want to mislead the court because of my recollection.
I know you're not intending to mislead the court, counsel. Let me move on, though. What about this document? What about the email showing that Mr. Goebel's office had reached out to Dr. Mahan? Why was that not disclosed to the defense?
Because no one knew it existed. What happened was Mr. Goebel, during the hearing, was adamant, and I cited it in our brief, but he was absolutely adamant that, let's see, he said that Mr. Goebel is saying that well, actually, no, that was the motion in limine, which actually, I need to tell that story in order to give context here.
I appreciate you telling a story, but today is our chance to ask questions, so thank you for listening. But I would like an answer to my question, though. So this document, this email, is first brought up to the court and the other side in front of the jury. You would agree with that?
No, absolutely not.
So it was disclosed to the court and to Mr. Goebel before it is presented to the jury?
It was, no, Your Honor, it was absolutely brought up beforehand. What happened was Mr. Goebel moved in limine to prevent Dr. Mahan from being able to testify that he had taught Mr. Goebel things. And Mr. Goebel stood in front of the judge, and this is before the trial that reached the verdict in this case. He moved in limine, and he stood before the judge, and he said, absolutely not. He said he would take the stand and swear under oath that it is false that Dr. Mahan taught him, and that's at page 57 of the transcript. And the judge said, well, Mr. Byrd, you know, if Mr. Goebel is saying he hasn't been taught, he should be able to testify to that, and I don't think we want this going on. And the judge said, I'm quoting, because Mr. Goebel is saying he's not been taught, and this is at transcript 71, that the judge was going to grant the motion in limine, and Dr. Mahan was not going to be allowed to testify that he had ever taught Mr. Goebel anything. Later, Goebel said, and this is at transcript 183, what Mr. Byrd has said about Dr. Mahan teaching me is blatantly false. We are always across the table from one another. Dr. Mahan is always giving opinions to the plaintiff. And later at T225.
What about the email, though? I'm asking about the email.
Give me one more second, please indulge me. To say Dr. Mahan taught me is obviously not correct. That's at the end of day 1. This is before the trial has started. They're doing motions. It's 5 o'clock. The judge says, whoa, this is a lot. I'm going to reserve. We'll resume tomorrow. Mr. Byrd went and talked to Dr. Mahan and said, you will not believe what just happened here. And Dr. Mahan said, are you kidding me? And he forwarded Mr. Byrd the email. And Mr. Byrd showed up in court the next morning and he said, Your Honor, I need you to revisit your motion in limine ruling because I reached out to Dr. Mahan last night. I told him what Mr. Goebel has unequivocally sworn to you, and Dr. Mahan sent me this email. That is when the email came into being. Mr. Byrd didn't know the email existed. Not until he called Dr. Mahan after Mr. Goebel unequivocally, multiple times, swore up and down that Dr. Mahan had never taught him. And the email says, from Mr. Goebel, I've learned more with you in the last several meetings than I have in the last several years.
We're talking about different emails, and I apologize. I'm talking about the email where the paralegal had reached out to Dr. Mahan in this case.
Oh, that's not Dr. Mahan, Judge Jay. So what happened is the paralegal subpoenas had gone out, and the
No, I think the question.
My question is the retention of Dr. Mahan in this case. Asking if, yes, that's what all of my questions were about.
I'm sorry, I completely misunderstood
so
you.
we've disconnected, but let's focus then.
Okay.
So I'm talking about for Ms. Pruitt, I believe, the paralegal to Dr. Mahan, saying we'd like to retain you. Now, the first mention of that is in front of the jury, correct?
No, Your Honor, these emails aren't in front of the jury. This is all being done before the trial starts. There's
The
2
one-
days.
The Pruitt to Mahan email is done before the trial.
Your Honor, in these hearings, the judge did 2 days of hearings before the trial started. And
The second trial or the first trial?
the second trial.
No,
So,
I'm-
in-
I
I'm
think
talking
the
about
question goes to during the first trial.
Correct.
During the first trial, when Dr. Mahan was on the stand and got a question about potential bias, whether on cross-examination or on redirect, Mr. Byrd brought up the email, well, you got hired by defense counsel in this case, or they contacted you.
Thank you, Judge Evander. That's my question. Yeah, and then redirect in the first trial of Dr. Mahan, the first time this email of the contact came up in front of the jury, correct?
Your Honor, I could have missed something radical, and I'm confident that Mr. Angel will correct me if I did. But in the first trial, what happened was that Mr. Byrd asked Dr. Mahan on redirect, has Mr. Goebel ever hired you? Mr. Goebel instantly was on his feet and said, objection, I want to approach. And he said that Mr. Goebel, or Mr. Byrd, is suggesting to the jury that I have hired him in this case. And that's when the jury was excused, Dr. Mahan was brought in, there was a voir dire of Dr. Mahan. So I have, and like Mr. Angel said, it's a 12,000-page record, but if you look at the initial brief, and I can grab it really quickly because I quoted from it, there was they proceeded no further. The judge granted a mistrial because the judge said, based on Mr. Goebel's argument, that Mr. Byrd had suggested to the jury that Dr. Mahan had been hired in this case and had given a bad opinion, and that the jury would then have some reason to believe that Mr. Goebel was hiding something, and that for that reason, based on Milburn and Suncharm, the judge was going to grant a mistrial. That first jury, I could be wrong, but I don't think at all it never got past. Mr. Byrd's question was cut short. He said, has Mr. Goebel ever hired you? And then, objection.
No
And-
reference to this case,
No reference to the email.
correct? In the case, meaning is there, were you contacted by Mr. Goebel's office in this case? You're saying that doesn't appear in this record,
Where Dr. Mahan was asked in front of a jury in the
Correct.
first trial.
correct?
In the first trial, Your Honor, I would leave that to Mr. Angel. Like I said, I do not recall that happening. My recollection is that the judge granted a mistrial based on the fact that Mr. Byrd had asked Dr. Mahan, has Mr. Goebel ever hired you?
Well, there's a big difference between ever hired and hired you in this case. It's my understanding he was asked if he was contacted in this case, which is a big deal to this particular judge.
If you will give me 1 second. So it was at R7399. Ms. Rodriguez's counsel asked Dr. Mahan, has my law firm ever retained you to be an expert witness in a case within the last 3 years? Answer, I don't believe that you have. No, the answer is no. Question, all right. Has Mr. Goebel's law firm retained you to be an expert? Mr. Goebel, objection, Your Honor, bolstering. The judge sustained the objection, so Ms. Rodriguez's counsel requested a sidebar. And then they argued, and the, let's see, I'm looking for the citation where, the judge sustained Mr. Goebel's objection without prejudice. And then in cross-examination, Attorney Goebel said, nice to see you. We've met many times before. I wouldn't say many. It's always in this type of situation where we're typically across the table from each other. Well, not always. And then, Dr. Mahan, there was some implication in your direct that my office has previously retained you. Some implication in your direct that my office has previously retained you and that you've testified for somebody in my office. That's not correct, is it? You've never testified for either me or anybody in my office in any case, have you? And that's at R7529. Dr. Mahan responded, "I just don't recall. I mean, I don't remember it." And the point there was, and then after that, after Goebel asked those questions, Mr. Byrd says, "Dr. Mahan, I'm going to go all the way back to the first set of questions asked by Mr. Goebel some time ago when he began saying that we have met many times before, but that it's always been this type of situation. That's not accurate, is it?" Answer, "That's right." Question, "In fact, there have been many times when Mr. Goebel's met with you in the last 3 years to hire you to be his expert witness." Answer, "Yes, I've worked for Mr. Byrd. I've worked for Mr. Goebel." Question, "And in fact," actually, here we go. "And in fact, Mr. Goebel attempted to hire you to be his expert in this case, the Lil
Counsel.
Misette Rodriguez case. I believe that's correct. Yes, that's at 7537.
Well, counsel, that's my question. It took us a long time to get there. That's a big deal, is it? Isn't it a big deal? In front of the jury for the first time to ask that kind of question, that radioactive question, suggesting that he had been contacted by the defense, and something about that was different than they wanted it to be, and then the jury for the first time hears that. Isn't that a big deal?
Your Honor, the only reason Mr. Byrd did that was because Mr. Goebel had asked him, "You've never testified for either me or anybody in my office in any case, have you?"
Counsel, back to where I started. Did Mr. Byrd approach the court and say, "Mr. Goebel has opened this can of worms, Your Honor. I'm going to ask Dr. Mahan about an email I have, and I want the court to know that before I present this to the jury"? Did he ever do that?
Yes, Your Honor, at R7400.
He said, I'm going to ask Dr. Mahan about an email?
No, Your Honor, he didn't ask about an email, Your Honor. He said, "In fact, Mr. Goebel attempted to hire you to be an expert witness in this case." And Dr. Mahan said, "I believe that's correct, yes." There was no mention of the email.
Well, that may be worse, that he attempted to hire you in this case. So he doesn't differentiate between a paralegal and Mr. Goebel. But here's this court's point. Should not Mr. Byrd have gone to the court before he went to the jury with that and said, "I'm going to introduce this. This is something that potentially could cause us to have a mistrial in this case. I want to have the court's permission before I approach this witness with this document and/or ask this question"?
Your Honor, I would implore you to please, pages 10 through 18 of the answer brief, we quote from exactly what happened, and I only have 1 minute left. Mr. Goebel opened the door in his opening statement when he implied to the jury that Dr. Mahan was a lackey for the plaintiffs, he only testified for plaintiffs, and Mr. Goebel asked or said, "It's always in this type of situation where we're typically across the table from each other, right?" That was Goebel's question to Mahan, suggesting that Mahan never works for the defense lawyers and that Mahan's never had anything to do with Goebel. And Mr. Byrd argued to the judge, "Hey, listen, this isn't fair. He's making a false impression. He's misleading the jury.
Let me
I
ask
should
you-
be able to correct that."
Yeah, let me ask you this. What was the time difference, if you can recall, between Mr. Goebel signing interrogatories that he had hired Dr. Mahan 7 times and the time of this first trial? Do you recall?
Your Honor, I couldn't tell you with certainty. I want to say that it was 2 years. But the point there is that when it came to the Bulla case, for example, Mr. Goebel sat in a deposition with Dr. Mahan. Dr. Mahan had Mr. Goebel in his home.
Okay, let me, and I understand that. Let me, the real issue I'm struggling with is, let's assume that the trial judge had the record supported a determination that Mr. Goebel had lied to him on several occasions, either in the sanction hearing or had lied to the predecessor judge in the first trial, or both, but at least some record evidence supporting the trial court's credibility determination. You'd agree that on the discovery issues there is no prejudice to your client. Would you agree with that?
Your Honor, I don't know the depth of the actual records that were produced, so I think that it's fair to say Mr. Byrd did get the records that Mr. Goebel
Right,
got.
but there's nothing in the record that suggests that Mr. Goebel got something that he shouldn't have gotten in those medical records, even if he may have followed the, violated the rules of discovery, if you would. There's nothing in the record that he got something that he shouldn't have, which prejudiced your client.
Your Honor, I think that that is a fair representation, but
Okay, so if we have a scenario where you don't have prejudice on the discovery, and you have defense counsel making dishonest or misleading statements to the trial judge, of which the client is not a participant at all, what are the policy reasons for sanctioning the client as opposed to sanctioning the attorney?
Your Honor, I think that it is, and I believe that it was you who wrote it in the Bowers case,
I
that,
think it was Judge Cohen in his,
well, no,
well,
actually,
I
this
said
is,
the sanctions should be imposed. I didn't say
You
what
said-
sanctions.
lawyers, as officers of the court, have a special duty to avoid conduct that undermines the integrity of the judicial process.
Right.
And here, Judge Jay, if I could address your point about,
But the point is, on that, I didn't say which sanction, or who should be sanctioned. So I'm asking you, if we have a decision to make, and I don't know which way we'll go on this case, but if we had a decision to make, if we did find misconduct, and we had to address what the sanction should be, what should guide us on whether the sanction should be against the lawyer or against the client?
well, Your Honor, I think I have a few responses to that. Number one, it should be based on the severity of the conduct. And here, Mr. Goebel, it was not one isolated lie. It wasn't an oops, I forgot. In one breath, in opening, he says, oh, well, I don't remember hiring Mr. Mahan. But then in that first trial, when the jury is sent out and Mr. Mahan is put under voir dire, Mr. Goebel examines him for several minutes about, don't you remember the agreement we had in this case where you told me that I couldn't hire you anymore? So he can't remember that he ever hired Dr. Mahan in opening. But then when Dr. Mahan is the first witness, an hour later, he's able to remember and do this voir dire about not hiring him in this case. That's just one example of the fact that Mr. Goebel takes liberties, and he does them for the benefit of his client. Now, whether it's Publix or whether it's an individual, I don't think that they should be treated differently.
Why
Because
is that? Why is that? Why not differently?
Because they are both clients. They are both entitled to a fair trial. And when they hire lawyers, and in this case, let's be honest, it was a car crash. We know that it was the insurance company that hired Mr. Goebel. But when you hire your lawyer, you trust that they are going to obey the rules, that they're not going to do something to get you in trouble. And when they do, that's why they have malpractice insurance. Your Honors, if we say, lawyers, if you do something terrible, if you violate the rules of civil procedure, if you see them as guidelines and you can say that you don't think it's a meritorious objection, so you're just going to ignore it. Or if you're going to lie to the judge to get a motion in limine that will benefit your client, and then if it hurts your client, there's not going to be a strong sanction, a severe sanction to deter you from doing this,
Why not
what
sanction
message are we
the-
sending to the lawyers?
Very briefly, and I'm indulging the chief who's been very gracious with me, but to follow up on Judge Evander's question, why not sanction that lawyer? Why not cause that lawyer to bear the brunt of the bad behavior? And I can't say how bad that may be, but it could be really bad. But why is the client here bearing that brunt of that bad behavior? That's again what I'm trying to understand.
Your Honor, the brunt of this bad behavior when the pleadings are stricken is that now the people who hire Mr. Goebel know that he has been sanctioned for something that was found to be severe, and that as a result, he's not going to get repeat business from those people. His reputation is going to be harmed. And that is the point, Your Honors, is that yes, these sanctions are severe, but we cited the cases in the brief where you said we would have upheld it had it been done. In Adams v. Barkman, you upheld striking the pleadings. Yes, it's a severe sanction, but it exists for severe circumstances. And here, there are two situations, both...
I think you made your point. Thank you.
Thank you, Your Honors. And
Well, you've gone 6 minutes past. It's not your fault, so
I appreciate your time.
So, yeah, that's
Judge Jay and I will take the blame for that.
that's right.
We will.
Yes. Judge Lambert, you were remarkably quiet.
So this is the new guy we hired, eh? All right. I'll say it this way. You have a minute 25 in rebuttal, but okay.
I'll try to stay within those parameters, Your Honor.
Well, you answer as many questions as you asked, up to at least another 6 minutes post that.
Thank
We
you.
want to be fair to everybody. Don't want to sanction you for being quiet.
To begin with, in the order I heard them, the Jones case, I think a critical distinction there is that there was actual prejudice to the clients in that case. The public's hid knowledge of a witness who, by the time they disclosed him 7 years after the fact, had forgot who the people were that precluded the plaintiff from performing substantial and material discovery that affected the actual litigants. That's a critical distinguishing factor that puts this case nowhere close to that one.
How about the Adams case? Was there anything in that case that the client was at fault?
So the short answer to that question is no. I do think that this court perhaps gave a little more deference to Judge Dickey. I know he was at the end of his career at that point, and there's a footnote that discusses his experience, and also he presided over both of the trials, which here I know that the abuse of discretion standard is somewhat circumscribed when you're looking at a past, what happened with a prior judge. And in that case, there were three things that happened in front of the jury. And to answer, Judge Jay, your questions, to clarify some of the record issues, it wasn't an email that was sent to retain Dr. Maynard. It was a letter. I think that may have caused some confusion. And it was not, the letter was never shown to the jury, but it was brought up in front of the jury. But then it came out for sure in a proffer. And what I was looking for in the record there at 7556, there was a question with Judge Jacobus, and Judge Jacobus asked Mr. Byrd, now, when you did that, you knew about this letter, right? You knew about it, right? And Byrd says, of course. So yes, he was planning on pulling that out in front of the jury as a surprise. There's no question about that. And I completely agree with Your Honor that the proper way to handle this sort of bombshell evidence is to call a sidebar. So I intend to perhaps go down this road, may I? Which ironically is exactly what happened in Bowers, which is what, of course, Mr. Goebel got in trouble for. The irony there is obviously fairly deep, as it is in these several cases with these lawyers.
Well, the other irony in the Bowers case involving Mr. Goebel is that the document that he improperly displayed to the jury was a medical record, but it happened to be a medical record from a doctor who wasn't treating the patient on an issue in that case, and it happened to be for the purpose of showing the jury something that didn't go to the patient's medical treatment, which is why we have the rules given the right to object.
And I don't know that record. All I know is the four corners of that opinion. I know Your Honor certainly knows it better.
It's in there.
And I did read it, obviously, at getting ready for today. And
Well, let me go back to the point on the credibility determination. Okay. Mr. Goebel's position below was primarily, I forgot. And Mr. Byrd's position was, there's no way in the world you forgot.
Essentially, that's how I read it.
All right. So the judge sits there and he listens and observes, and there are some things in there which, frankly give me, the idea that you remembered 24 cases, this person used Dr. Mahane, but you can't remember the 7 that you did, or that you send all of us here have talked to experts before, but the idea of going to a home office and getting a lengthy dissertation and then writing a letter to the person saying, I learned more from you in a few hours than I've learned in years, those are hard things for an attorney to forget. But the bottom line is, how can we sit up here and say, we agree with Mr. Goebel, he just forgot? Or the judge erred in not finding that he forgot.
And I understand the appellate angle that
Right,
Your Honor is
right. That's my
presenting.
real question.
I would like to I'm in my red here, I would like to clarify a lot of those facts if I could. First of
Okay.
all, that is truly a home office of Dr. Mahan. He's routinely deposed
I
there.
know it's a home office.
Yeah,
I got it.
there's a lot going on there, and the 6 or 7 cases, only one got to a deposition. A letter goes out, he's retained, the case settles, and that sort of thing. So it's easy to forget things that basically didn't even happen. All that
But he
being said,
remembered 24 from Mr. Byrd. That's my point.
he was likely prepared with that for cross-examination purposes at the time. I think that's where he was in that trial. He was preparing to cross-examine
But
Dr.
when you
Mahan.
prepare for redirect to say, but, Dr. Mahan, haven't you also been retained 7 times by Mr. Goebel?
And again, at the point Dr. Mahan was going to testify, it was as a treating physician, not an expert. So he wasn't prepared to go through the whole rigmarole that you would with a retained expert who was opining. That changed over lunch in that case, as Judge Jay, you noted. I just think that this record, when you have this amount of back and forth on a sort of an impromptu hearing in this case, on the morning of a jury trial, the veneer is waiting when this is going on. I do think that this court can find that the evidence here was not substantial enough. Remember this competent substantial evidence standard with this level of uncertainty where we have to defer to the trial judge. I don't think that we're at that point yet, particularly given the gravity of it. And if they want, look, Adams versus Barkman, there was an evidentiary hearing in that case. I know in Robinson versus Ward, there wasn't, but in that case, there was, I think, 8 or 9 instances of misconduct, and the trial judge who sat there also did not believe the lawyer's explanation. I don't think we have that here. We need to have, in a case like this, with this amount of disputes, there had to be a separate hearing. I hope that answers Your Honor's question.
Thank
And
you.
then my final point as to the insurance comment I heard, I think we all have seen, and I know Your Honors have seen it, where just because someone has insurance, you get rung up for $5.5 million that Mr. Byrd asked for. Mr. Rhodes is going to bankruptcy, whatever comes of the insurance issues after the fact. So the focus, as Your Honors have, I think, driven the case that way, has to be on these 2 litigants.
Okay.
And unless there's any further questions, I appreciate the
we're
extra
good.
time we've had today. Thank you very much,
Thank you
Your Honors.
both.
Thank you. Let's be my kinder, gentler person after the first of the year here. Okey dokey. Thank you, counsel. All right.